Artificial Intelligence, Law and Justice, Session 17. This is Session 4 of the Copyright and AI and Copyright. In this session, we will look into Generative AI and Copyright Law, how Generative AI is creating new issues, and then also some problems for copyright and copyright law and practice. Basically, this is continuation of what we have earlier discussed. Many of the points will be in continuation, but there are also a lot of new points. To give a recap, in the last session, we discussed issues relating to synthetic data. We also highlighted the issues on text data mining and AI. Further, we listed how these are being addressed and then what are solutions being suggested. So, generative AI's impact on creation. When we talk of generative AI's impact on creation, we all know that generative AI's core strength is generative, in the sense that it is creative capacity. So obviously it has got some impact on creation. How big, how small, how large and long term, we are not very sure. But it is creating significant impact on the creation process, because what it does, it is blurring the boundaries between human and machine driven creation. Human driven creation, we all know, sculptures, paintings, poems, photographs, even photographs for that matter, lot of things are whatever human made. We know about the creativity and the creative process and all. But in generative AI, the blurred boundaries between human and machine driven creation are creating a whole lot of conceptual problems as to who exactly is the creator, machine, system, or AI, or is it human, and then what is their respective relative contribution to that. Applying to specifically to copyright, the question comes that who can be attributed to or assigned to the rights as author, because normally copyright hinges upon one fundamental concept called author and authorship. And then in the case of generative AI, since it is very creative and then it can enable creativity on its own, it can create many things. Where exactly this label should be fixed, and then whom exactly we should be attributing to that. There is existence of authorship in AI generated works. Attribution of authorship in such works is also possible, but there are a lot of questions here. In the sense that if I write a novel using AI, I can acknowledge that AI has been used in this novel writing that. But as we have seen, AI cannot claim copyright on its own. I can claim copyright on its own even if I acknowledge that I wrote this novel using AI system, AI tool, or whatever tool it is. But neither the persons who provided me the tool nor the ones who developed the tool can claim authorship, because I merely used a tool. On the other hand, by using AI generative tools or generative AI, I can endlessly create works. I need to do some prompt engineering. I need to give it some hints. I need to upload certain files. I need to ask it to certain things, and then it will keep on generating. So, in one sense, if I can create generative AI very creatively, if I can use generative AI very creatively, I can keep on producing output after output, and then still I can claim authorship. But copyright does not depend upon the quality of the work. Copyright depends upon, within quotes, the authorship, and then who can be proved or who can claim to be author, and then that needs to be established. So even for low quality works that are generated by AI or through generative AI, humans can claim copyright. Of course, it all depends on the market, in the sense that you may generate 100 books with generative AI, but none of them may survive in the market. Nobody may buy it, or they may just become yet another, things done out of curiosity. So attribution of authorship in such works, one can claim that using generative AI I created it, but I'm still the author. But even if copyright office accepts it, even if it is there, proliferation of such works again, is something that is bound to happen, and it is already happening. AI generated works are increasing day by day, but they are not exactly the ones where the AI gets the credit for copyright. So the paradox is that AI may generate thousands of works, but then the person who used AI will become the author. But to avoid this, a test has been proposed, that is, whether AI is the author or who is the author. Then question is four-step test. The fourth test for authorship is identify persons involved in the creation process. Then determine the type of AI systems used. Now identify the persons means it could be a single author or team. Then the type of AI system used, in the sense that this will help us as to what is the generative capacity or the creative capacity of the system. Whether did I use a very one which is a very elementary one without much creative capacity, or did I use a sophisticated one, it will help. Then the subjective element exercised by the persons involved. What exactly subjective element? To what extent they edited the process? To what extent they help the AI system to do? And to what extent their work is there, or their involvement or their contributions there in the book, in the work, or whatever it is. For example, I write a book with the assistance of AI running 200 pages, but I don't publish it as such. After getting the book output from AI, I start extensively reworking on it, revising it, adding paragraphs, text, and then rewriting the full chapters and then shuffling the chapters. So my judgment, my work, my assessment is also as part of that. I'm not simply using what it generated. And then who is able to access control over the execution of work? Is it me, or is it someone else, or is it the system? The sense that system itself can simply write and then produce. So in that case, who is able to access the control over the execution? Suppose if the process is that system generates, but then I intervene, I review, and then ask the system to recorrect, and then I say delete this many pages, write again, and then give an output. I'm able to exercise control. So this fourth test step will tell us as to who can claim authorship or with whom the authorship can be given. But to go into this, let us also look at what is the evolution of AI in the creative process. Computers have been traditionally used by many painters, artists, starting from Microsoft's Paint and Word Assist in creative works. And then they all rely on creative input from the author, in the sense that MS Word Assist under Microsoft Paint is more or less driven by us. The system helps us to write, but then it itself does not contribute to in the way of generating ideas or giving ideas or executing things. They are helping us in the sense that we are using them, and then we are painting, we are creating works. So the creative input and the creative labor comes from the person who is using it. But with the advancement in AI, improved data acceptance algorithms, AI's processing capability has enormously increased. And then now AI is also part of so many things in life, ranging from autonomous driving, recommendation streaming services, in everything, many of the things which you've already seen, AI is part of that. So AI, is it really creative? What exactly we mean by creativity when AI recommends me streaming service? These are big questions, because we think that recommended systems are not creative. But someone will say they are also creative because they also organize something, they also decide something, and they tell you creatively what you should look. And then AI in creative fields is there, image production, photography, filmmaking, that's also possible. So the transformation of the creative process through AI has come as a part of the larger transformative process, the creative process, which started with computers. But we should also keep into mind one thing, that much before the advent of Microsoft Paint and Word, computers were also used for creative purposes in a different way. This is that even the earlier generation of computers, some sort of creativity was possible. So it is not that all the creativity in computers started only last 30 years or so. But the problem in copyright, and particularly in the AI context, is that the AI programs are very autonomous in the sense that they do on their own. So when AI writes a novel, the question is, do we say that there is need for human intervention, and what is the level of human intervention? But we need to determine authorship for many reasons. One, who exactly can be identified as an author and then attributed as an author and then given the copyright. Two, authorship is necessary, and then it has to be proved, or it has to be accepted if there is going to be a case of infringement of a previous work, or some other issue where it is found that the book is very obscene, or it creates violence, or it could result to violence, or it spreads hatred, or it talks derogatory about women, like that. So the problem is, authorship is not a mere copyright question alone. Authorship is also a question in law. If there are certain things are to be done against the author, or if the author is to be persecuted for something, authorship should be clearly established, and then the court should be proved if it is contended. But when it comes to publication of AI generated works, It applies both to artist and everyday user. Like my students who use AI to make PowerPoint, it tells them that this is created using this. So are they the real authors or is the system the real author? That's a big question. On the other hand, lot of researchers, lot of students, many people use AI very creatively, but not everyone goes for copyright and not everyone takes authorship straight away and then say this is I am the author, this is my work. Because only artists and then many of those who use AI for creative purposes, only selective people or only few go for copyright protection or only few seek copyright protection. So AI generated works could be any number, but then the copyright by default will be applicable to anyone who has generated it. But those who stake copyright or those who apply for copyright and then or who get it registered in their name are not many compared to the output generated through AI. When we look at it, there is also possible how do we interact with AI systems and then who decides what is creative. See, AI systems need humans to work with them in the sense that they can do on their own, but when we intervene, when we talk to them or when we give input comments or when we fix the parameters or you say, read the novels of Fyodor Dostoevsky, read the novels of Jane Austen, read the novels of Chetan Bhagat. Now, after reading all this, you write a novel on your own. If I say that, yeah, you will produce. But the creative choice is being made by whom? If the humans make the creative choice and then give it, look, this is the plot, this is the narrative, and this should be imitating the style of Jane Austen, or you should be imitating the style of Rowling, I should tell it. So the creative choice, if I make in the process, I am intervening in it, or I am simply giving a answer clue to the AI and then start working on it. So there are a couple of things like genre, style, technique and format and then the choice of the model and input data. So the preparation phase itself, choices have to be made because if I want to choose or if I want to test, I can take 3 or 4 generative AI models and then assign the same task to them. I can assign the same task of say, you read all the works of Fyodor Dostoevsky and then come up with something like, to me, The Idiot in 300 pages. If I assign the same task to different AI systems currently available in the market, the output from them will be very different because although they are AI systems, although they are LLMs, and although they are fundamentally trained to write, they will be coming with totally different works. So the choice of model, input data also make a huge difference. But they make a lot of complex actions. But as we say, and as we have seen many times earlier, if you ask AI as to why did you write in this style, or why did your character commit murder at this stage and escape, or why did your character decided not to take any position and then committed suicide. But AI wouldn't be able to explain to this, nor AI when it is writing would have been able to anticipate this decision by the character and then go forward as to what next should do. In the sense that AI generates the output without within quotes understanding or within quotes the narrative capacity to explain. So outputs are there. It could, if I anticipate something from the AI that it has read all the works of either Dostoevsky and it is going to give me something like Idiot, it may turn out that the book might be titled as Idiot, but then the output could be totally very different. It could be totally different story altogether, not at all something similar to the Idiot. So this is again, if AI is the author, it should be able to explain another narrative. Like an author who says, I chose this is the reason why this character appeared in this stage, and then logically, rationally, this character disappeared in this stage only to appear later. And authors have their own narration, authors have their own rationale for each character. They can explain, but AI can't. But when humans rework and then repurpose the draft versions and then re-edit and do everything, the creative choices are already being implemented there in the sense that humans take over the creative process at some point and then they make it for better or worse. But if we apply the human test, then we need to differentiate between the developers and third parties. And then we also need to develop the idea that systems into partially, highly, and fully autonomous because Not all AI systems are fully autonomous. Some systems are partially autonomous, they are of the earlier generation. Some are highly autonomous but not fully, and the later ones or the latest ones are fully autonomous. So, depending upon the system's autonomous capacity, the tendency for or its authorship right or authorship claim can be questioned. And more importantly, we can even say that the creativity of the ones that are partially autonomous is less than the ones that are fully autonomous. But again, it's the question of whether the partial autonomous is itself is sufficient to produce something and claim authorship, or should we say that only the fully autonomous ones should be given authorship. This again is not a matter of debate, it's not a matter of contention. It is a matter that goes into the fundamental question of authorship and then for fundamental issues in creativity. But if the user or the person who within quotes ordered or commissioned the output, you takes lots of free and creative choices in the sense that he doesn't or she doesn't take the fully output, does lot of editing, shuffles it around, adds certain things, changes the narrative, changes the tone or changes the active voice, passive voice of the characters in many places, and then puts everything together, edits it, and then tries to come up with a coherent novel. So in that case, the user or the author does lot of subjective judgment, also involves creative process. So ultimate thing is that control over execution. Who controls the execution? Here the author or the one who commissioned the study. But a highly autonomous system need not even be told by humans or need not even be told by the within quotes the author to work. A highly autonomous AI can simply generate an output given the preconditions and given the instructions or given the what we would call as prompts. So if you implement the 4-step test, we do get some answer, but that answer may not be very crystal clear. So problem here is that while the legal certainty is we need to think about, there is a big gap between the traditional authorship and AI. We need to promote legal certainty in that. So, developers or authors is possible when they are working partially or with highly autonomous. Because developers, they decide the logic, they decide the rationale, they decide the algorithm, they set the way AI will work. So, they know that the work which will come out of AI, they have seen the narrative, they have seen how the system is going to work, they have an idea about it. So, does it mean that developers would have anticipated all the, or can we say that developers know that in the initial stages itself that if the AI is going to write a poem, it will be only based on Emily Dickinson and not anyone else? No, it's very difficult to say that. So, developers as authors, yes, feasible, but then can they be full authors? They can at once say that they are the ones who set the tone or who set the path, but then they are not the ones who drove the process. So developers are not the persons who drove the process, they enabled the process to go through. Third parties can become authors when they use the AI system. Developing authors must work with partially autonomous or edit and highly autonomous outputs originality so that they can claim as authors. But initial AI generated work is not considered as human authorship. Edited work may be considered as human authorship because human involvement is substantial. It not only changes the text content and direction, but also it involves the human taking control as editor and then taking full responsibility for the output as an author. So here, fully autonomous things, when they are in place, they make things very complicated. For example, a fully autonomous thing may write a very sophisticated text or a very fantastic thing, but that text in the end may not be something which a typical novel or a traditional novel might look or might read. That text may be good, brilliant, well written, it might have been able to imitate the style of some authors, but its literary standard or literature quality may not be great. Because we know that machines, at least as of now, do not have the capacity to think like us or imitate us and then write like us, or at least if not us, as at least the great authors in literature. On the other hand, in future, this can become a totally different one. Autonomous systems become more sophisticated. They themselves may have the capacity to edit, revisit, and also to rework and then revise. In that case, can we say the authors, the sense that they should be given as authorship? That again is a very debatable point, because we cannot predict how the systems will evolve. But even if you go by case, then it becomes a little easy in one sense, okay, we know, but complicated, because proving exactly some of the claims related to authorship, control is not all that simple. One way is that fair outcome and case-by-case examination, results align with your EU copyright framework. The EU copyright framework says fair outcomes for creators. So this is consistent, this 4 test. But works created without significant effort cannot be attributed to users, because if the author does not do, or if the author simply gave a prompt and then vanished, he cannot or should not be given authorship, because their contribution is not great, it's very minimal. At the same time, if the author does lot of editing, rewrites, reworks, then to imbue originality, then it is possible authorship could be considered. But it's also possible the attribution could be given to developers who developed the system if it is shown or if it is proven that that system has been used solely to develop literary work like novels, poems, short stories, novella, and or dramatic works. In case of Mario Kong, he created output through AI system development utilization. So, the reasonable to attribute resulting works to him as author, because he did system development and utilization, and he was able to prove that he is an author, because attributing to him passed the 4-step test. On the other hand, aside turning AI authorship is problematic, we saw. As continuous advancement happens, certain things may change. But need for ongoing legal refinement is also necessary, because adapting laws to keep up with AI development is a complex, challenging, and very, very difficult task, not just in copyright, but also in many spheres, including patenting, which we will see soon. So after all this discussion, we also need to understand, at least in the context of copyright thing, how are the generative AI models are trained so that they are able to give such outputs. Generative models like OpenGT, they use deep learning. Deep learning involves neural networks with multiple layers of nodes. And then deep learning information is processed at different levels of complexity through deep layers. Each layer identifies simple patterns, subsequent layers recognize complex patterns. And then AI models learn from large quantity of data. Further, patterns and rules are identified during the training or used to create new content. So AI creates content out of content, learning out of learning. And then AI models encode patterns or numerical parameters, they don't store the entire data sets. And then generative AI models can sometimes recreate identical or near identical copies of training data. So when the model is being trained, it can create an entire or almost identical sample thing from the training data. It is also possible that when we want to generate synthetic data, we can use some trained data as a model and ask it to generate synthetic data, which we could say that the synthetic data should resemble 70% of the original data or 90% of the original data. We can also give some conditions for generating synthetic data. That's a different topic, but I'm saying that it is possible when we think of generative AI that even synthetic data can be developed like that. So what does the GPT-3 training data? It is generative model require extensive data. OpenAI. For we have the common crawl data set, then web text to data set, 2 data sets of books, English language Wikipedia. So it was again fine-tuned with curated data sets. So this is the training data of which is needed by GPT-3 version. But here the problem is developers are increasingly worried about people knowing about their data sets, how the training was made, and then who trained it, and what exactly the whole lot of training which was done based upon copyrighted material, non-copyrighted material used for unused authorization. Because I could have asked and then got copyright from the copyright holder, authorization to train the model. But then I would have used it for different purposes, or I would have used it in excess of what I asked for, or in excess of what the rights were granted to me. And there is also the problem that copyright holders may try to sue if they know that the training process used their copyrighted works. So what the developers do not tell us exactly what was the ones that were used in training data. So they are becoming very secretive. Instead of giving detailed explanations, they give some misleading explanations or few descriptions. So GPT-3 had much more transparency, and then GPT-4, that transparency was lower. And then we have seen why they are not going for extensive transparency, and then why they prefer secrecy. There are very good commercial reasons for that. And then there are also some reasons like if information is available in full, commercial actors can use it to hack the system. Commercial actors can fool the system and then try to do certain things by hacking the system. So this increasing secrecy has got both elements. One, it could be done for safety and then to avert risk in the future. It could also be done for commercial purposes and then also to avoid claims being made that there was a misappropriation or infringement of copyright works. So there are two things like arguments for transparency, arguments against transparency. Both are somewhat valid, but then the full access approach has got multiple benefits because it helps everyone. Transparency is good for all. And then more important, datasets being publicly available. Others who want to build LLMs or models, they can use it. Of course, after getting all the valid permissions from others. And then third party can independently verify training data. This independent verification of training data is very useful if we want to know whether the training data was adequately representative or whether it did contain any bias or discriminatory data, or exactly was the training data was given in such a way that it was fully representational and it was error free and the quality was high. So it is also possible that if the data sets are being made available and then full access is given to those who want to test it, then certain things can be said they are transparent. But providing full data set access online has got both problems in the sense that somebody can hack it or somebody can use it with malicious intentions. So full access is a very desirable one, which is a transparent one. But who should be given full access again is a debatable point. For example, I can say that I can give full access only to trusted public authorities or trusted institutions with whom I trust in case of litigation, or full access can be given with some conditions or with under some restrictive conditions, and then full access can also have non-disclosure, non-binding agreements. For example, after giving full access, I can say that the person who had got full access will not reveal that what contents were used, will not reveal that what contents were obtained from where, and not only that, will not use any sensitive information about the data. On the other hand, other approach is to give gated access. Gated access is that if you are having too many volumes of trained data and then managing that is difficult, so right holders may object to being fully available. Licensing deals do not cover unrestricted access because when the licensing deal is given to a AI developer, it is given for a specific purpose. That does not mean that the AI developer again has got the right to put the data online or give the access to third party. So when the data access given by the copyrighted person to the AI developer does not make that the system will give the output or will make the material, or the AI developer will make the material available in public domain for all. Again, it could be closed. So in case of data sets with personal information, in case of data sets where copyright owner has granted access for training purposes with a string of conditions, gated approach is preferable. But still, users can say that I want to check. Gated approach is fine. I have every reason to suspect that you have used 10 books written by me. You have used 15 articles written by me. You have used some of the text from the books I edited. And then I can list out and then say I want to only cross check I want to check as to whether have you relied on them, have you used them for training, and what sort of attribution was given. And I can also want, or I can also ask the developer to clarify as to, can the developer guarantee me that the attributions to me or the views attributed to me in the output or during the training data are correct? That's also important, because if I write 10 books and then my views are being attributed to X, Y, and Z, and then my views are not attributed to me, but somebody's views are attributed to me or for some reason or other, then I have every reason to not only get worried, but I can also sue. In the sense that this wrong attribution is an question that, as not only as an author but also as a contributor to the knowledge, I can question that. So there are a whole lot of things, but then there are a lot of logistical issues like giving access, monitoring access, and ensuring that the ones who do have access do not abuse it. Because somebody can claim that they have a very genuine interest in having access, but then that could turn out to be with some malicious intention. So even the gated access approach, although there are merits, has got a lot of problems. So the transparency from the rights holder's perspective is very, very important. And then they have a stake over there. But then there are also issues which are very easy to resolve, which are not easy to resolve. So if we can respect the right holder's perspective on transparency, we should also understand that even if the developers want transparency, there are some very clear-cut valid reasons which do not go in favor of transparency. So the copyright issues with training AI training data are many, and then, as I said, the question of synthetic data is also there. But whether the feasibility and timeline of synthetic data, people are not sure. But see, there are two things we need to be very clear here. When AI training data consists a lot of public domain works, which may not be outdated, some of the public domain works are very valid, and then which have got not only longevity in the sense that they are being repeatedly read, repeatedly used, and they also still have popularity. People do buy them, they use them, and everyone talks of them if they are classics. So what is protected by copyright law and then what is not protected by copyright law in the training data has to be sorted out, at least by the developer, so that the developer knows if there is going to be a contingent plan, if there is going to be an injunction or there is going to be a suit, he will be able to justify that he has used only the ones in public domain, not all material which he has used or protected by copyright. At the same time, Creative Commons license, what sort of attribution is being given there need to be looked into, not just Creative Commons license, any such license. Suppose if the license forbids any further commercial use, or if the license says that commercial use is permitted, provided you share the additions or you share the innovations you made there on similar terms with others, then that would become really problematic, because no developer would prefer to do it. Now the problem is, there are two things which we need to understand. One, when I read, when I memorize, it is a mental process. It is something my mind does. It is not equivalent to a digital copying or photographic copying or a Xerox making copying, or it is not equivalent to I read the text here, I write it here, I read it here, or it put type in the computer. It is not. My memorization could be partial, could be full, or I may memorize just 4 sentences of a 20 sentence poem because I like the 4 sentences. But when computers read, they also memorize. This is something like they also see. So whether that could become an infringement or not is a very debatable point, because they do not copyright by their existence. Memorization does, but the memorization again is not something equivalent to reproduction. So if we talk of reproduction in digital format, exact reproduction, then memorization may not meet that fully. So direct reproduction of training data could be infringement, but then non-verbatim also still infringe if it contains recognizable protected elements. So somewhere we need to segregate in the final output as to what is the recognizable protected elements, what is not. But the exclusive rights in a copyright also includes the right to adapt, right to translate, or for public communication. So these rights could be violated. But again, there is not much clarity in it because the legal copyright regime is yet to come to terms with the whole idea of AI generated outputs and then the way AI using them. But clearing rights for training data is also very difficult because who will pay a license fee for to him? So the AI developers prefer to use content without identifying or seeking permission because then they can say that you prove that I have used it, then we can talk of paying you some money or paying you some sort of remuneration. So a lot of litigation goes here. So the varied impact of training data transparency on copyright is very important. So US fair use versus the EU Article 4.3 of CDSM are very different. So the point here is that since the legal system themselves are not really clear on what is fair use or what is mean by, in the US context, fair use exception. In the context of AI tools developed in some country, adapted in some country, reused or made better in another country, whole lot of problems will arise. So problematic assumptions will also be there because if I'm going to use the fair use doctrine of European Union in India, it won't work. Indian one is much broader. It is also much more wider, and then it's also something that is based on our reading of the copyright, where certain things are totally permitted for non-commercial academic purpose. The US fair use restriction or the right is very limited and very restrictive. So if I transpose one over the other in different contexts in different countries, there will be chaos. But there is no universal definition or there is no universal standard for fair use. So this means that AI developers will have to be sensitive to the copyright exceptions and then exemptions in different jurisdictions. The AI Act of the European Union tries to address this in detail, and then I have listed here. I'm not going to explain in detail because we are not going to discuss the AI Act in detail. So there are some benefits and the limitations of transparency requirements which we have already described. So what we need ultimately, we need broader policy measures, we need balancing of rights holders versus promoting AI development, and then there need to be effective policy stakeholder engagement process has to be done, and then amending copyright law in rushing for it will not work. Some sort of varied approaches should be done, and then more importantly, depending upon the jurisdictions, there could be some tailor-made exemptions. For example, if it is India, applying the same broad fair use doctrine lock, stock and barrel will not and should not be a good policy option because the original intention of the broad fair use was not to develop AI systems. What was certainly not to develop them for commercial purpose and use. It was done for a specific purpose of promoting academic, scientific research and then for educational purposes. So extending that to AI systems in the broader context in India will be something that does injustice to the primary objective of the fair use in India. Similarly, we need to go into each country and then trace the roots, identify the cases, identify the rationale behind the exemptions, and then how the whole idea was developed and they have arrived at. So unless we contextualize, we cannot think in terms of broader policy measures or exemptions. Of course, Europeans they come up with certain things which may or may not be suitable in other contexts, but then only by a comparative analysis of the fair use doctrine, particularly when it's applied to AI, we can come up with some tangible, relatable, rational policies. So there are a lot of challenges, and then future of copyright law in the context of AI, we need to really think on many things. And then the whole question of balancing innovation IP protection is the big elephant. It is there in patents, it is there also in copyright, it is there wherever we try to link any innovation with IP rights, and then particularly in the case of technologies like AI. So the next one we will talk about AI and patents. In these 4 sessions, we have touched upon the broad issues in copyright and AI. We have also gone into extensively on many topics, but let me also tell you, or let me also caution you that we have simply scratched the surface. We have not into extensive detail of many complex issues for the simple reason that is beyond the scope of this course. True, it is also uncertainty, legal uncertainty being prevailing. It's also not fair at this point of time when offering a course like this to put certain things as conclusions or conclusive evidence for one policy or against another, or even to say that most probably in future that copyright policy will move into this direction. Even to guess and then make such a thing may not be fully correct, because policy options are not, they are evolving, they are not fully exhausted. And then what EU does, what other countries will do also will change. Then things may change depending upon how countries want to promote AI and then how the copyright stakeholders want to negotiate. So these are complex matters, but trying to understand even the complex matters in a session like 4 is a necessary beginning, but not sufficient to get a advanced idea of what is the developments happening in copyright in AI. So we will devote the next 2 sessions for AI and patent.